thank you everyone for sticking around for what truly is a hot topic, not just in the context of the DMA or competition enforcement, but for all regulators and citizens of the world, to be honest, and that's artificial intelligence. So in our 75-ish minutes, what we're hoping to do is answer the question that the Commission has been asked and has been grappling with pretty much since the DMA came into force, and that's how is this ex-ante, forward-looking law going to effectively capture this fast-moving market, and should it, and how, and in what way? So to answer that question, we have a very, very expert panel. Starting to my immediate right, we've got Elodie van der Hend, who's Deputy Head of the Digital Economy Unit at France's Autorité de la Concurrence. The Autorité has been one of the foremost European agencies looking at this issue, including with its generative AI opinion issued in July 2024. So Elodie is going to touch on that and then discuss how, as a non-enforcer of the DMA, but as a competition authority in Europe, she's thinking about these issues. And then next to Elodie, we have Constantina Banya, who's a partner at Jared & Partners, which obviously needs no introduction here today. But before that, she was at the European Broadcasting Union and led the group through the DMA adoption process. So she's the perfect person to talk us through the technical and legal issues when we think about AI. And then at the end, we have Nicholas, who is ruining our all-female AI panel, but we'll allow it because he is one of the senior policy advisors at the European Publishers Council, which advocates on behalf of publishers and other large media organizations at the EU level. And in the DMA context, that includes being one of, well, first of all, the EPC is one of the complainants in the Commission's Google Ad Tech case, which was a real inspiration for the law, and is now one of the commenters and has, in fact, given opinions to the Commission recently in the context of its AI and DMA consultation. So without further ado, I'll hand over to Elodie, who will start with some high-level comments about generative AI, AI in general, and the competition authority view.
Thank you. So we, as the French Competition Authority, decided to work on AI in 2024, and we decided to focus on two main issues which we thought were really important to talk about. The first one was how big tech companies that are already present in other connected sectors, may enter into the AI market, or like the AI sector, more rapidly through means that may not be entirely about the merits. And the second angle was about partnerships and, like what was the acquisition strategy in the AI sector. And so we looked at, the value chain and the input that were necessary. And so we saw that there were three main inputs, which was, computer power, and then data and talents, in addition to investments. And we saw that the sector was, you had, obviously major big tech companies. Some of them were Google, and Google and Microsoft were, vertically integrated, and they were different strategies than, for example, Meta and Apple, which were at the time maybe less involved in the AI sector. We focused on the upstream level because we thought that that's where the major digital companies had the most advantages, because they had access to a lot of data, obviously, whether internally or access to third-party data. They were involved in the computing power because they are big cloud providers. They are also developing, they are like partners and competitors with respect to NVIDIA, because they obviously are buying a lot of GPUs from NVIDIA, but they're also developing their own processing cards, and so that's that's an interesting development. And obviously there is a war on talents in the area because this is very technical, and so so we focused on the strategy at the upstream level, and so that's where like the development and the training mostly of foundation models happen. And at the downstream level, so we saw that at the upstream level, like the number of providers were quite small, as opposed to the downstream level, which seems quite dynamic, at least for the moment. And we analyzed, obviously, a lot of the competition issues that were raised with respect to, like at every level of the value chain, with respect to computing power, the fact that because we had issued an opinion on the cloud sector a year before, and we saw that a lot of the issues that we had identified on the cloud were actually persistent and even getting worse in the AI sector with respect to cloud credits, for example. We saw that the fact that like because you had some big tech companies that were present through all the levels of the value chain, but also present in other areas connected to AI, you could have competition issues obviously being raised with respect to tying and with respect to like the development opportunities that you may have. I'm not gonna like explain all of the competition issues, and we can come back to that maybe later. But the bottom line is that we saw that those were cause for concerns, and we issued some recommendations that I may go back to later.
Thank you. And before we sort of talk about how the DMA might be able to resolve some of those issues, Konstantina, could you just talk us through a bit more of the technical side about, the AI value chain and how competition law plays into all of that?
Sure. And let me just start by thanking Elodie and their team at the Autorité, because the work that the Autorité has been doing on these issues is really impressive. And may I also take the opportunity to say that the clouds are gone, and I'm very optimistic about DMA and AI, and I will explain why. But I wanted to make a few remarks on whether the DMA covers the value chain as Elodie described it, and I will not do it by having the boring discussion, is AI overviews a separate service from search? I wanted to focus on the valuable inputs as Elodie identified them. Elodie referred to talent, computing resources, and data. So at the upstream level, the Autorité, in its opinion, identifies 3 different types of providers: IT computing providers, supercomputers, and cloud service providers. The first 2 are clearly not covered by the DMA. As we know, the DMA very much focuses on the service level. Cloud service providers, however, are mentioned in the DMA in the exhaustive list in Article 2. Have they been designated yet? The answer is no. But let me just take a step back and explain to you why cloud service providers are useful for generative AI. First of all, to state the obvious, high computational and storage needs. So the data sets are massive, and they demand high capacity storage. The second obvious example is what we call scalability and flexibility. Cloud infrastructure allows AI providers to scale compute resources up or down depending on workload demands. And that, of course, makes a huge difference, because that way AI developers do not need to invest in hardware and AI infrastructure more generally. And the third point, that is perhaps related to the first point, is data management and security. Cloud platforms offer integrated data storage with high security standards. And when we start talking about training models on AI-sensitive data, we understand how high security demands are particularly essential for the development of the models. So that gives you hopefully a clear idea of why cloud service providers may become gateways, or have become gateways, one might say, for AI developers to access their audiences, to access end users. And let me make one final remark. Several companies on the upstream level, several companies that have been designated as gatekeepers for many of the services they offer, like Microsoft, Google, and Amazon, offer cloud services. We can be discussing for hours why a designation has not happened yet, but I just wanted to flag that we are talking about vertically integrated companies, and we are talking about long-established concerns. Let me now give you a couple of examples of how I think this fits the DMA discussion. The Autorité and the CMA report on foundation models have identified several concerns that are particularly relevant to cloud services markets. These are not new concerns. These are very old concerns. So one example, Elodie alluded to it, is tying. There is a prohibition of tying in the DMA. Another point raised by the French report is the so-called issue of cloud credits. So these are trial offers in the form of service allowance that is offered by cloud service providers to AI developers, guaranteeing free access to the service for a specific amount of time, okay? And based on the findings of the French report, these cloud credits appear to be offered at certain target groups, which means they might be discriminatory in competition law terms, but also in DMA terms. There is a provision in the DMA, a very small provision dealing with a very easy issue to enforce, front access to the platform. But this provision, Article 612, does not apply to cloud services. It applies to other types of providers. So perhaps in the context of the DMA review, this is something that we may want to discuss. So this gives you an idea of how things are covered or dealt with by the DMA at the upstream level. But I wanted to take the opportunity to make a few remarks on data, the other valuable input. And I think it's important to make a distinction between first-party data and third-party data. First-party data is data that is already, I will say, owned or controlled by the company. Okay? And of course, gatekeeper platforms have access to vast amounts of first-party data because they offer massively popular consumer-facing applications. Is there really something we can do about it? The answer is probably not, even though the DMA broadly, vaguely, and ineffectively, in my view, addresses the issue. So there is a provision, Article 5.2, that prevents gatekeepers from combining data extracted from many different services they offer unless users grant their GDPR-compliant consent. This is actually one fundamental point on which I disagree with the DMA text, because in my view, this is a market regulation instrument, so we should not be concerned about how the GDPR assesses or addresses data processing, which is subject on the normative standard of consent. We should be concerned about how users actually behave on the market. And the phenomenon of the privacy paradox is very well documented in empirical research, and I don't need to convince you that this is not the most effective way to address data accumulation. So unless we see a major revision on that front, I don't think that the DMA can do much about first-party data. But this is where it gets interesting, and perhaps this is where Nicholas will convince us about what can happen with third-party data. So third-party data is data that is used by AI developers, data that is in many cases copyright protected, data that belongs to somebody else, third parties, third-party content providers, such as news publishers, and image repositories, okay? And of course, it's worth mentioning why third-party data is so valuable for AI firms. First of all, to state the obvious, AI developers prioritize clean content, and media content that is consistent, complete, and accurate is highly valuable for AI firms because it requires less cleaning at the training stage, okay? But these models also rely on what we call RAG, Retrieval Augmented Generation, or grounding. They need to ground on live web content to be able to provide contemporary responses. So if you want to go to Perplexity today and find out what Trump did yesterday, that will most likely rely on live web content. And we need that because training data sets have cutoffs. So that gives you an idea of how valuable third-party content, third-party data is to AI developers. Can the DMA do something about it? And the answer is probably yes, if we tick some of the provisions of the DMA. One obvious example is Article 6.2. But 6.2 has its limitations because it's limited to non-publicly available data. Of course, it reflects the Amazon investigation. But what happens if, for example, Google scrapes data that it then uses in competition with its business users to provide another service, for example, Gemini or AI overviews, okay? Another obvious example would be, again, 6.12, and I think Nicholas will talk about it, so I leave it at that. And that hopefully gives you an idea of the fact that the valuable inputs in AI markets, namely data and computing resources, are already covered to a large extent by the DMA. So the question may not be, does the DMA cover AI? The question might be, does the DMA cover AI effectively? And if not, what can we do to change that?
Thank you very much, Konstantina. It is, I agree, incredibly important that we know exactly what we're talking about when we're talking about AI, because it can be a bit of an amalgamous term. Nicholas, can you comment a little bit, picking up on what Konstantina was saying, but could you talk about what you're actually seeing on the ground in terms of issues that have arisen in the AI context and how we might start to think about whether the DMA could address those?
Sure. Hello, everybody. Thank you for inviting me, first of all, in this timely debate, and to share my perspective from the press publisher side. I might be dressed like one, but I'm not a lawyer, so that's a declaration. Artificial intelligence has been one of our focus in the past 2 years, I would say, because it touches a lot of angles from the media and publishers' business models. So we do have, of course, the copyright angle, which is very, very important for us. It does touch upon ad tech, and of course, it touches upon competition that we hope that the DMA will be one solution. Just to highlight that generative AI, it's not just another wave of innovation for us, it's a major shift. As for example, these systems do not just scrape individual articles, but they ingest whole websites, they ingest our news, our images, our features, our format, and they have access even in paywall articles and website layouts. And they do that without consent, without compensation, and with complete lack of transparency. They then reproduce publishers' content in summaries or outputs that compete directly with our journalism and without the editorial standards, the legal liability, or the accountability that define editorial media. So publishers are on the front of the disruption of AI that is most often built by gatekeepers, and it has been integrated more and more into gatekeepers' core platform services. So we see that what used to be an intermediary platform connecting user to content, it has now become a destination, providing answers designed actually to keep users with its own walled garden and not linked out. Search engine, social platforms are embedding AI answers directly into their interfaces. And the result is less visibility for original journalism, less traffic to publishers' websites, and fewer opportunities for publishers to actually turn those users into subscribers. Referral traffic, we see a plunge of at least 50%, with some reports mentioning even 70%. So publishers have no control over how our content is used for training, and we still have no control of how the new content is used publisher content to enrich outputs. So we feel like journalism, it is harvested like a raw material here. The harms are clear, as Konstantina also mentioned. In the input side, it is used without permission. And in the output side, the reporting is substituted by AI-generated material. And in the market, we see dominance, which is reinforced, with gatekeepers exploring publishers' work to strengthen their own position. However, let me stress something, that publishers are not against innovation or against technology. We themselves, you are using AI, but try to do that in innovative and responsible ways in order to support our editorial mission. But if AI, and especially generative AI, builds its future by extracting our content, we risk to lose something irreplaceable: trust, truth, pluralism, and democratic accountability. This is why we are advocating for licensing, fair partnership, and enforceable rules that are essential. They are not only about the future of publishing per se, but they are about the sustainability of journalism and ultimately our democracy itself. So for this reason, we see multiple points that the DMA can address those issues. So in terms of scope, the DMA already applied to gatekeepers' core platform services, and its definitions are technology neutral. So for that, we believe that generative AI services offered by gatekeepers should be seen as either part or closely linked to existing core platform services like search engine or social networks, meaning that the obligation, such as the self-preferencing, should definitely apply on them, as well as interoperability requirements. Then there are the transparency and fair access provisions that can be used to tackle discriminatory treatment of publishers' content in AI environment. For instance, where AI overviews or AI assistants systematically privilege gatekeepers' own services. The data use that was referred earlier, Article 6.2, obliges gatekeeper not to use business users' data in competition with them, and this should be interpreted to cover publishers' content and data that they are used to train or fuel gatekeepers' AI models. And finally, it's important to have some future-proofing of the DMA, and the Commission should be proactive in monitoring all those AI-based services, and where necessary, use Article 19 to bring them formally within the scope, as general AI services that they are outside the control of already designated gatekeepers represent a new category of intermediary platforms.
Thank you, Nicholas. So we've heard that, yes, there are some concerns, and that initially, yes, it seems that the DMA could be an answer. But obviously, the DMA doesn't exist in a vacuum. The EU has, the AI Act alongside a bunch of other laws. So Elodie, what do you see as the role for competition authorities specifically when it comes to AI?
I mean, obviously, that was a big discussion when the DMA was negotiated. It's pretty clear that the Commission is the sole enforcer of the DMA. It's written quite clearly in the regulation, and obviously, national competition authorities' role. I mean, the debate about the national competition role was settled in a different way than the competition law regime, which is, like we can support and assist the European Commission. So basically, if we want to initiate an investigation, we obviously need to let the Commission know. If we want to issue an interim measure, we need to let them know very fast, right after the interim measure decision is being taken. If the Commission is planning to do something in France, they obviously, that's a good practice to inform us, and so then we can assist. And we can also, we have the power to investigate, in principle, DMA, potential violations. I have to say, though, that Benoît Cœuré, the president of the French Competition Authority, already said that given our limited resources, the French Competition Authority will not be able to be very proactive in this area. Just to give you an example, where the investigation services of the French Competition Authority, it's 100 people, and the digital team is about 10 to 12 people, including telecom. So obviously there is limitation in what we can do, but that doesn't mean that obviously we are still trying to be very active in the digital area, which is we have issued, I think, an important decision in the Google related rights case. We are issuing opinions on the cloud, on generative AI. And something else that I want to mention is there is not only competition law, but you also have a lot of various issues about privacy, for example. And so we have a lot of work going on, especially with the data protection authorities, because in the digital world, it's not only about antitrust or regulation, but you have a flurry of other regulations. The AI Act, the Data Act, the DSA. So I think, the competition authorities have to navigate sort of this complex landscape, and I think that's another dimension that people need to be aware of.
Thank you. And honing in more on the Commission specifically, it's just recently, I believe on the 25th of September, closed its call for contributions as part of the review of the DMA, but also specifically on an AI questionnaire. And that itself can be seen as a signal that the Commission's saying, yes, we hear everyone calling, making noise about AI, and yes, we are looking at it as a separate issue. I wanted to ask Nicholas, as one of the respondents, or the EPC as one of the respondents to that questionnaire, what were some of the issues you highlighted in your response, and then opening it up to all the panelists, sort of in the context of this DMA review that the Commission is in the midst of. What do you hope will come out of this review, and any changes, if at all, that you might expect to see?
So we were very happy when we saw that the Commission added a specific AI section, a specific AI questionnaire. As a no, we're never happy with the deadlines anyway. They tend to be a little bit on the short side, and especially for an organization that has to consult members is particularly challenging, when also summer is in the equation. But a known problem. So we call for many things in our submission. I would like to highlight perhaps the most important ones for us, and it is of course, as I said in my introduction, the designation of the various AI services. So there are different types, and Konstantina might help me with the legal details here. But we see already the existence of new services that they are presented as part of core platform services. So this is one category that could come already under. We see that they can come already under the obligations of the DMA. AI overviews could be an easy example for that. So obligations such as self-preferencing or front conditions should be taken into account.
Sorry, just for those in the audience who might not be familiar, can you describe a little bit about what exactly AI overviews is and how it
Sure. So AI overviews, which is a relatively new service that Google has launched in Europe, I think in March. So instead of, in the beginning, when you type a search query, in the beginning, instead of you seeing the typical blue links, you are actually seeing a response, a ready-made response that an answer to your question that the AI, generative AI, has used various sources for that, which actually drains the need from the user to click on specific links in order to visit the website and find out more. So you have a ready question, you don't need to do anything, that's it, you remain at the Google environment. If you are on mobile, you are not even going to see the links because actually the answer will be your whole screen. So this is definitely has a prominent position in the Google search page results. So this is one category of generative AI that we think it should be covered by the DMA. Of course, then there are other generative AI instruments that they are not part of designated core platform services, and those are the ones that we think that the Commission should look with potentially a fresh eye. That includes browsers. We see more and more than those AI agents are being incorporated into browsers, and a lot of AI search engines, like, for example, Perplexity, they have launched a new browser that uses actually, it works like a data harvesting tool, if I can say that, because a URL of an address that a user visits, it contains a lot of valuable information. It contains advertising information, it contains location information, etc., etc. So this information are used then by those companies to serve advertising as well, hyper-personalized advertising. So we are going into various levels of intrusion is not the right word, but various level of harvesting data from different sources without even the user know about that.
Thank you. And Konstantina, do you have any thoughts on the AI questionnaire and what might come from it?
I want to provoke a little bit the audience because I won't talk about the AI questionnaire. I will talk about the original questionnaire for which we had multiple weeks to respond to. And I've seen some of the replies that were published, and I think almost everyone made the same point. The DMA text or the DMA review process needs to clarify that generative AI should fall in scope. And my question to you is, doesn't it already? Because if we are supposed to have a paralyzed commission until the legislative process is completed to have a clarification in the DMA that generative AI or AI more broadly is covered, I think we're doomed. And the other thing that I hear from gatekeeper platforms primarily is that we need more evidence. Do we though? So let me just break it down for you and give you my views on whether generative AI is covered by the DMA. I think that when we talk about the DMA, because I hear a lot about the DMA being a non-flexible, a rigid tool, I don't think it is. In fact, I think it is a very flexible tool. And I liked how you described the DMA at the beginning, Charlie. You mentioned that it's an ex ante and forward-looking tool. And I think the DMA is exactly that. It's both ex ante and forward-looking. And when you go through different recitals of the DMA, you will see references to the principle of technology neutrality. And one of the things mentioned in the recitals is that the definition of core platform services for the purposes of the DMA must be technology neutral. So when we go through the list of designated service or services that qualify as core platform services in the DMA in 2.2, can I ask the following question? Do you see commerce marketplaces in the list? Do you see app stores in the list? No, because these services have been designated as online intermediation services. What about search engines? Couldn't we raise the argument that generative AI chatbots qualify as search engines, given that they meet all the definitional criteria laid down in the DMA? So I think one point to make is that, in my view at least, generative AI could easily fall under one of the types of core platform services already included in the DMA. The other scenario that I see is what Nicholas already mentioned. What happens if AI as a service is integrated in an already designated service? For example, in-browser AI assistants. This is something that, and to state the obvious here, this is something that we have seen, and to state the obvious, that part, that functionality of the service would be covered by the DMA, and in fact, the gatekeeper would need to comply with respect to that part of the service with the DMA at large. And in fact, if we go back to the designation decision of Google, we see that the Commission designated Google Play services, that is the middleware between the software and the operating system, because it thought that this was an integral part of Android OS. So there is case law in the area that can help, okay? As far as I know, Google did not appeal this point. The third scenario that I see, and this is essentially the thing that is right in front of us, is that we tend to forget that the DMA covers many services that are not core platform services, or services that may be core platform services but have not been designated yet. Let me give you a couple of examples. 6.2, in the way that data is used to compete with business users at a different segment of the market. 6.5, self-preferencing of a product or a service that may not necessarily be a core platform service or a designated service, and so on and so forth. So AI, generative AI, and the issues that have arisen, for example, self-preferencing, tying, share locking, all these issues are already to some extent addressed. But this is where it gets tricky. When I read the compliance reports, the most recent compliance reports prepared by gatekeepers, I have not seen an explanation of how they try to comply with the DMA with respect to the generative AI services they offer. This is a huge question mark, and of course, in many cases, gatekeepers have not even gone through the trouble of updating their compliance reports, so they remain exactly the same. But this is an area where the Commission needs to push more so that we can understand whether anything, if anything, is done to comply with respect or vis-a-vis generative AI services in the context of the DMA. I'll leave it at that.
Thank you. So we've heard that the DMA already should cover some services, that it can potentially cover some services, and then maybe there are some services that aren't quite encapsulated by the DMA yet. Elodie, did you want to first of all respond to anything that the other panelists have said, and secondly make any comments that might align with the authority's view and what the Commission has been asking recently?
No, I mean, maybe just to jump on the issue of generative AI being covered by the DMA. I think it raises several questions. I don't really have all the answers, but I think one is I think it's very interesting that debate about whether if it's embedded in the existing core platform services or if it's like a standalone service, is it covered by the DMA? For the French Competition Authority, we suggested that the Commission maybe look at model as a service, which is in the cloud. It's the marketplace in the cloud that allows model developers to be in touch with potential users, and we thought that maybe it would fit the definition of a platform, of a core platform service, because there are a major point of contact between developers and users. And so we thought that would be, maybe for the Commission to consider in that debate. I think the other point would be, I think Constantina and Nicolas explained very well the fact that, maybe generative AI may be already covered in the obligations, and if it's not, are the obligations applicable to all the situation as is, or do you need to update the obligations? I think one question that is very relevant as competition enforcers is, if we know that the DMA doesn't cover all the competitive situations, if it's not a core platform service, or if it's a new obligation that is being, the purpose of if a gatekeeper is enforcing a new practice that we deem is a problem. But how do we collectively, with the European Commission, with the sector, regulators, make sure that we don't have under or over enforcement? How do we make sure that it's not an administrative burden for the companies, and at the same time that we go and enforce the full-fledged of our mandate? And I think the last question for me would be, what would success look like with respect to generative AI being included in the DMA? I think the answer was maybe given this morning by the European Commission when they said it's more about creating opportunities for companies, and I think that's very interesting.
Thank you. And Constantina, Nicolas, do you want to chime in?
I just wanted to raise another point that I omitted earlier, which is there is another category listed in Article 2 that has not been designated yet, and that's the virtual assistant. And so we're going to see more and more the rise of virtual assistants acting actually as AI gateways. The next generation voice assistant that we all going to have on our phones, cars, home devices, wearable, etc., they will be AI powered. They will no longer just answer simple queries as they do today, but serve as conversational agents, delivering generative AI generated summaries, recommendation, and services. And more and more experts say that it will become the primary way that people interact with information, the commerce, and of course media. So this accelerates the substitution effect that users receive just a simple answer from an assistant rather than clicking through a multitude of results, all having presented various options in front of them. So it will make the independent media providers' role to shrink even further. And of course, then that's for further down the line, but we can also discuss about a lock-in effect, making more difficult for users to switch those services. So it's not going to be one click away or one voice away, because users, they will share a lot with those type of entities, get to know them, and it will be incredibly complicated to actually change or move from one service to the other. So this is another thing that is coming up.
Yeah, it's not just a case of switching, it's more a case of breaking up with your Alexa, for example, to move to someone else. Constantina, did you have any thoughts on this one?
Yes, I actually wanted to make a couple of points building on Elodie's point. When we discussed the DMA review and all the points that Elodie raised, I think it's important to have a look at the possibility for the Commission to adopt delegated acts. This is something that we have not thought extensively, in my view, but there is a lot of potential for the Commission to address a lot of the issues that we are discussing without necessarily revising the text of the DMA from scratch. So I suggest you have a look at, I believe, is Article 12, that sets out the conditions under which the Commission can adopt delegated acts. So just to give you an example, one of the possibilities concerns Article 612, or a provision of the DMA that only applies to specific types of core platform services. So you know that 612 currently covers search engines, app stores, and social media networks. So what if we wanted it to cover cloud service providers, for example? This provision that I talked about allows the Commission to extend the scope of a specific provision to other types of services not already covered. So that gives you an idea of how the Commission, if it wants to, how the Commission can be creative to address some of the issues we are discussing. The other point that I wanted to mention, which I think is a very important one and builds on Elodie's point, the point on over-enforcement and under-enforcement. So obviously, there has been a lot of discussion around regulatory cooperation. I think that a lot of member states, and the UK, which is no longer a member state, do it fairly well, but I have not seen formal fora of cooperation where this cooperation takes place. It's primarily informal discussions that are being had with regulators when, for example, a specific practice may cover privacy issues and competition issues and perhaps even DMA issues. I think we need to see more of that to avoid over-enforcement, avoid under-enforcement, and more importantly, avoid conflicting outcomes. Because the one thing that I would not want to see in the area of AI and more generally in the digital sector is two regulators, for example, the European Data Protection Board or data protection authorities, saying something completely different from what the Commission says when it enforces the DMA and so on. So I think that we need to have more of that. You may know that the DMA has a high-level group, but again, this is not a formal forum of cooperation. It's essentially a forum for exchanging ideas and not for enforcing the rules collectively in a coordinated manner. So Filomena Kirik always tells me, you want a high-level group 2.0, and I say, yes, I want it, because I think there will be a lot of potential for interesting work that avoids conflicting outcomes with harmonized decisions across the EU that provide legal certainty to gatekeepers and, of course, tackle the same issue from different perspectives, but in a coordinated manner.
Thank you. Elodie, did you want to respond to any of the points on cooperation? Okay, great. So we've been having this debate for several years now. You know, it's not new, and we've heard from Commission officials earlier today, and I don't know if Thomas Kramler is still in the room, so I'll paraphrase him when he said in an earlier panel that, you know, AI could be the next wave of disruption, but it could also be a further avenue for gatekeepers to close off and cement their market power. We just don't know yet. We don't want to be too late. We don't want to move too early. That's a difficult one for every regulator, is when do we start looking into it? So a question I want to pose to the panel off the back of that is, why do we still not know? Why are we still at the talk but no action stage? And if there were to be some sort of action, where do you think would be an appropriate place to move?
I mean, one thing I want to say is I've never seen any regulator being blamed of being too early looking into a problem. So usually it's the opposite. For us, the harm is happening now, not just for publishers, but for the whole range of content owners. So the DMA was designed, as you said, to be an extender regulation, and waiting until dominance is entrenched defeats the whole purpose. So I think the early the Commission gets into that and acts on that, the better for everyone. So really follow the spirit of the law here.
Thank you. Konstantina, did you have any remarks?
I don't think it's too early, but I also think we cannot blame the Commission for not taking action in this area. There are two important points to make. First of all, the work being done by national competition authorities, starting from the French Competition Authority and the opinion on generative AI. So one thing that I saw, which I didn't see in the past in relation to platforms, is that the European Commission or a national competition authority would open an investigation without necessarily understanding how the market works in practice. Now, here I do see a different approach to the matter. So obviously, ChatGPT became the fastest growing consumer-facing application we have ever seen, and that, you know, made antitrust bells ring. There might be something here. And this prompted a response by national competition authorities across the EU that launched sector inquiries. And they really tried to understand the market dynamics. The CMA did the same. And of course, the European Commission had, long before the DMA consultation, a consultation on AI more broadly, generative AI more specifically. So I think that the issues are known to competition authorities and regulators, and whether we have taken action or will take action, or action may arrive too late, I think that, one argument that I hear from gatekeepers is that we need more evidence and that these are fast-moving markets. I don't think we need more evidence. And yes, these are fast-moving markets, but these are also markets that tip, and we already know that. So I think that when the Commission comes in and says, let's try and see what gatekeepers have been doing in relation to generative AI, I think they are more than entitled to make the point and request gatekeepers to provide more information in their compliance reports, and of course do more when they engage with affected stakeholders, including AI developers. So I cannot really blame the Commission for not taking action, but we also need to bear in mind there is a lot of work that has been done over the past 2 or 3 years to understand the market dynamics. The Commission will, of course, have collected a lot of responses in the context of the more recent DMA AI consultation, and I expect to see action on that front very soon by both the Commission and national competition authorities.
Great, so quite a hopeful outlook in that case. And Elodie, the authorities' generative AI opinion really honed in on not just access to data, but the value of data. How have you been thinking about that in terms of your work as an enforcer, but also how does that play into the DMA, and is it something that the DMA can address?
Yeah, so in the context of generative AI, obviously access to data is critical because, as we say, it's an essential input. And so, as antitrust enforcers, when you hear about an essential input, then, you have bells ringing about refusal of access or discriminatory access. And so we covered that in our opinion. Another thing that we thought was quite new was the fact that we noticed that you have a lot of agreements between big tech and content providers, and so obviously in principle those are not really an issue. It's great for it's great for Le Monde to have an agreement with OpenAI, and and so we can see that it has a lot of advantages. But on the other hand, obviously, if the amount that you give to Le Monde, for example, leads to exclude other companies to be able to conclude similar agreements with Le Monde, for example, then you may have exclusion issues, and that may raise a competition law issue. And so that's something that we saw was different, because if in principle you could say, if you have an agreement between Le Monde and OpenAI, those are the same kind of data, and Le Monde could very well sell the same sort of data to Mistral for a lower price, but then you have always the issue of incentive. What would be the incentive for Le Monde to sell the same kind of data for a lower price? So we thought that was an interesting economic and competition law issue, and so we thought that the price of data was something that was very interesting. That's an issue that we sort of saw as well in the Google related rights case. It's not really about competition law because it was a lot about commitments, but what we saw was Google was using the training of Bard at the time, which is Gemini now, on content provider's website without obviously asking the content provider their authorization to scrape their data. And of course, there was no remuneration for that. So there was a problem of transparency, and there was a problem of the lack of negotiation in good faith. And so we think that in the area, that's something that we need to be aware of, and that was one of our recommendations in our opinion, was for maybe content providers to pay attention to maybe their power of negotiation, especially on the downstream level, because if at the training stage the amount of data may sort of dilute the price that that may be negotiated between content providers and big tech companies. At the grounding stage, it's actually very very pricey. When you explain the grounding stage, you have a training of a foundation model that is from January 1st to July 1st. But then if you have someone making a prompt asking what happened yesterday in October 2025. It's not going to be covered by the training of the foundation model, and so the value of the content provider, if you are Le Monde or if you have Libération or other newspapers, is going to be very valuable for the foundation model developer, and so that's why we think that there is a lot of margin of negotiations in that regard, and you have a lot of discussions in France at least about what should be the appropriate price of data, should you have collective bargaining and stuff. But that may be beyond the discussion today. And obviously access to data, I think, is covered a lot in the DMA. I don't know if the value of data, but I'm turning to the experts, is covered in the DMA. I don't know if it should. I don't know, maybe you can help us on that.
Two things. It depends on how creative the Commission wants to be. I think it could be covered under 612. But on that point, we also have the revision of the DSM Copyright Directive. And, you know, there are other provisions or other instruments like the Data Act, which says gatekeepers cannot have access to data. So companies that have been designated as gatekeepers under the DMA cannot have access to data that can be shared in the context of the Data Act. I think a similar approach can be followed in the context of the DSM Copyright Directive. So you can force gatekeepers to negotiate in good faith in a manner that is very similar to what you did in the context of the Google ancillary rights case, to sit down at the negotiating table and negotiate and find a solution, fair and appropriate remuneration for content providers.
Just to add something here, it has not happened yet in any market. There is no big tech that ever sit down with any media company to negotiate anything or any type of license. So to your earlier comment about, let's say, the example of Le Monde selling the data, no, they don't. Because they have never been asked. So the few existing partnerships that there are between AI companies and publishers, they are not based on remuneration. They are based, it is actually an act for publishers not to miss the train of AI and be present, very often with detrimental for them terms. There is definitely no payment, but it's mostly exchange of technology, perhaps, and it's not a license. It's not a license. That's why we always talk about and want to push a licensing framework, which will be applicable to all, and also compliance with rights reservations, because all rights of publishers that, you know, they publish their content online or in print, it doesn't matter, or audiovisual, the rights are reserved. So for anyone to use those rights for commercial purposes, they have to ask for permission, they have to ask for license. And this is our problem, that it is not happening today.
Thank you. So we're hearing about some very sort of difficult dynamics, but also a lot of transactions and partnerships between gatekeepers and other companies. And I think I just about have time to ask this question on the partnerships. An interesting element that we're seeing when it comes to sort of big tech / gatekeepers making these partnerships with other AI companies, if we take just as an example, Microsoft's partnership with OpenAI, Microsoft might be designated as a gatekeeper, but OpenAI is not. And therefore, you know, is there a way that any part of the DMA could apply to the services there? I wondered if you'd had any thoughts on those, and if not through the DMA, is there another way that these partnerships could be addressed by the Commission?
Yeah, I mean, in our generative AI opinion, what we explained was we didn't see at the time that the partnerships between big AI companies and foundation model developers were usually not triggering the merger control review thresholds. But we saw that, you know, you still could have some competition law issues because, you know, obviously you can have decisive influence, and we thought it would be interesting to sort of explain the minority shareholding and how they can trigger some competition law issues. We also saw that they were cause for concerns because you could see that, you know, for example, Amazon and Google, two competing big tech companies, were investing in the same company like Anthropic. You could see that you had, for example, Microsoft investing in Mistral and OpenAI, which are competing companies, and so that raised all sort of questions. And one thing that we saw was because it didn't trigger any criteria for review, there were some transparency issues, and that's why we suggested that maybe the Commission could update the Article 14 or at least have changed just at least change the template so as to, if there is a concentration in the sector of AI, they could ask some question about minority shareholding as well, just because we know through antitrust case law and guidelines that there may be some issues as well, and it may give some perspective on a concentration if you also know what's going on with respect to minority shareholding as well.
Did either of you want to comment further? So outside of the DMA, we've heard Elodie talk about, some competition issues that are arising that may not specifically fall within the DMA. So what can enforcers do, and what are they already doing to ensure competition without either dampening innovation or cutting off valuable market access for innovative companies?
That's me. Well, I mean, I think I've already talked about it quite a bit. So, it's been, only 2 years since designation took place. So I think, we're still trying to grasp the reality of DMA versus antitrust and how we can sort of navigate this landscape. We're still at the beginning of it because a lot of our cases were actually initiated before the DMA entered into force, and so we'll see. I think that's a question that we are thinking a lot now, and obviously we have a lot of dialogue and cooperation with the Commission, and so that's ongoing work, and we need to be very open and very constructive in the way that we talk to the Commission about it. But I think there is obviously a large playground for competition authorities, at least because otherwise I don't have a job. So.
Yeah, I don't think you'll be short of work, don't worry. Nicholas, I know that the EPC has raised some copyright-related issues in this area. How do you see sort of the copyright issues intersecting with the competition issues? Are they one and the same, or is there scope to do something different?
Good question. So to start with, copyright exceptions, which is what AI companies are claiming they have in order to use publishers' data for the training of their models, they never meant to be for those large-scale commercial operations. So the so-called text and data mining that there is in the copyright directive was for specific limited scientific purposes. And as I said earlier, all rights, they are reserved. So they need permission and they need to ask. And publisher has the right to agree or for whatever reason not agree. So the competition issue is, is it a competition issue, or we actually say that is the biggest theft of the century? Because what happened is we have commercial entities helping themselves to publishers' content, use them, and then resell it to publishers included with the various tools. So every one of us will in the end pay for something that has been built in stolen content.
So we're not talking about a minor issue here. It's something that really, as a journalist, something that personally affects my job, but also affects, the access that we all have to this kind of content. I just wanted to, before we open up the floor for audience questions, I just wanted to give each of our panelists the chance to make any final comments on the DMA and AI.
Perhaps a couple of points building on what Nicholas said about the interplay between competition and copyright rules. I got a question a couple of weeks ago at another conference, whether these are all issues that should be dealt with by copyright and copyright only. And the answer to that question, in my view, is the following. We live in a very complex environment, and the fact that something is protected by copyright does not make it irrelevant from the perspective of competition law. And the same applies to the Meta Platforms judgment, right? The court explicitly said that data is a valuable input in this market, so yes, we acknowledge there is a huge privacy issue to resolve, but that privacy issue does not make the data access issue irrelevant from the perspective of competition law. And I think we're in the exact same sphere here. Let me give you an example as to why all of these issues that we discussed today will not be addressed by copyright rules alone. So My answer started as follows. To be able to enforce copyright, you need to know what content was stolen, was used without permission. So first and foremost, you need transparency. This is something we do not have or until recently did not have. You know that the AI Act establishes a transparency obligation in relation to IP or copyright protected data, but the code of practice, personally, I found very underwhelming. So I don't think we will see this moving the needle a lot.
And just
Yes.
to add, the template is, because there is a template that AI providers can use in order to declare this transparency, is practically unacceptable for us. It provides very, very little information that is of no use to publishers.
Just to highlight this by means of example, yes, you can say the AI Act says that you need to provide a sufficiently detailed summary of the content you use to train the model. But if I'm a copyright holder and I want to enforce my copyright, what if I see that the AI developer relied on news archives? Does that move the needle for me? Obviously not. So transparency is point number one, and this is not addressed by copyright rules. The other point is very much related to the Google ancillary rights case. So last time I checked, the DSM copyright directive was not saying, oh, big companies like Google need to sit down at the negotiating table and pay publishers or more broadly copyright holders fair and appropriate remuneration. What the directive says is that if you choose to use this content, you need to pay fair and appropriate remuneration. And what if you engage in other practices that are not covered by copyright rules? For example, what happened in the French case, you say, you're not going to be indexed on search unless you give me a free license. Is that covered by copyright rules? The answer is no. So you already see that the AI Act, the DSM Copyright Directive and national implementations thereof, and competition law can all work together to achieve an outcome that actually does something to ensure competition for third-party content. Competition law alone or copyright rules alone will simply not make a difference.
As a way to conclude, maybe it's to say that, since our opinion, I think, you can see that there has been a lot of developments in the sector. We didn't talk too much about, like DeepSeek, or at least, like what they were implying about the fact that you have smaller language models now, and so you have a lot of, it seems that the market, at least at the downstream level, it's still very competitive, so I think it's a good sign. I think competition authorities at least need to be still vigilant, and we are still investigating the area. For example, we're working on a different subject than the DMA, but we're working on a contribution on AI and energy, which we think is going to be important in the future. I think also one thing that is important in terms of enforcement is if you are a business, a company, or if you are a user and you have and you don't really know if it's a competition law or if you think that's DMA, I think it's still worth going to see a competition law authority to talk about it. I think the more nexus you have to a member state, the more it's going to be valid for a member state to pursue this, because like when I talked about resources of the French competition authorities, the same for the European Commission, obviously, because they have a lot of things in their plates as well. So I encourage a lot of people to come and see us if they, if you're in France mostly, but to come and see us if you have issues. Thank you.
Can I make one concluding point? Just making sure that this is covered, because Elodie made the point that downstream we see a lot of competition. That is true now, and I want to remind everyone that the DMA is a symmetric regulation. When we discuss regulation of AI in this context, we're not talking about regulating all AI developers, including the small ones. We're talking about taking targeted action against companies that develop AI services in addition to all of the other services they have in a way that the market doesn't tip in their favor.
Thank you. Nicholas, any final remarks? Great. Well, in that case, let's turn the floor over to the audience. And I think we have microphones roaming around down here. Thank you.
Oh, thank you. Is it on? Yeah. Hi. My name is Hannah Melin. I'm Global Competition Counsel for eBay. And it was what you were saying, Elodie, that just a thought. So the Italian competition agency is investigating Meta for tying Meta AI to WhatsApp. WhatsApp is a core service, and they are working closely with the European Commission, they said in their press release. So clearly this is not Article 5.7, it's not Article 5.8, and the Commission doesn't think this is self-preferencing under 6.5. And so back to what you were saying, Elodie, perhaps the sensible or the right approach to these AI services is to actually investigate them and establish anti-competitive effect before assuming that they are harmful under the DMA. And it goes to the discussion that you were having about the DMA applying or not applying to AI services.
Yeah, I mean, I think your point is when you are when you're looking at a harmful practice, I think you can be tempted to put it under the DMA category because it's a list of practices, and sometimes it fits quite nicely in the regulation, and that may make sense to go to the European Commission with it. But I think sometimes I think it's useful to have a full assessment of. Can it be maybe more effectively conducted under competition rules, or is there an argument for the DMA? I think that balancing of interest is really worth it, especially if you're a company. Yes, and I think after that, if you're going to see the national competition authority about it, I think then that's up to the national competition authority and the European Commission to talk about what makes sense.
I have strong views on what you just said. So in my view, it's covered, but I will explain why. Even though it's not explicitly covered by 5.8, because 5.8 makes reference to subscribe to or register with, I also think that the Commission needs... Exactly. Exactly. So I would say it is. But of course, you have very strong limitations in 5.8, okay, because it needs to be a core platform service that meets the quantitative criteria. But I think, and this is where my point is on having strong views of this, there is an anti-circumvention obligation in the DMA that the European Commission has not used extensively. And in my view, this is one of the provisions that makes the DMA so forward-looking and flexible in many ways to be able to address situations of the sort. Because subscribe to or register with does not necessarily mean make a payment for something. It's being forced to use something even though I don't want it or don't plan to use it. So a creative thinking could potentially say, it's covered.
Sorry, not to interject, but why do you then think that the Commission doesn't do that? Why doesn't the Commission extend 5.8 in that way? Or why doesn't it think it's self-referencing 6?
I will reply honestly, and I will say it's the limited resources of the Commission that cannot go against every single case, every single problem arising in this market. Let's remember that the Commission is still in the process of completing the first non-compliance investigations, but this is where the point made by Alexandre Destrel earlier today comes in. We need more regulatory dialogue and more specification proceedings, and we definitely need more creative thinking when we enforce the DMA. So yes, the DMA, I agree with you, Elodie, will not cover every single practice arising in digital markets, but when you see that a practice might be covered but does not squarely fit the wording of the DMA, this is where the anti-circumvention obligation comes in. And the anti-circumvention obligation refers to the design of the user interface that subverts consumers' or end users' autonomy. And I think this is exactly what we're discussing here.
Hi, I'm Shubhani Ojla from DeBrow Blackstone Westbrook. I think a very interesting point was made about the risk of avoiding the risk of different regulators saying different things and different regulations leading to different outcomes. But then if we take the example of ChatGPT, now that it has a search engine, it risks designation under the DSA as a search engine with systematic risks. But under the DMA, it's not so clear because, yes, it can be in the search category, but there's some experts who argue that it should be a virtual assistant. So we actually have the potential for a different categorization under the DSA and under the DMA. And even within the DMA, you see that ChatGPT has the search feature. So only is that feature a search CPS or the whole bot? And if it's only that search feature, then what the rest of the bot is a virtual assistant. So this is already something we're seeing as a risk.
Lots of points you made there. That was 10 questions, not one. Starting from the definition of search engines in the DSA and the definition of search engines in the DMA. First of all, the fact that we refer to both types of services, regulated services, under two different instruments does not matter in my view, because the definitional criteria in the DMA and the definitional criteria in the DSA are completely different, okay? Now, I can tell you what Filomena said at a public event. We were co-panelists, and she said the following, and it was a public event, therefore I can say it. The fact that ChatGPT notified the Commission that it qualifies as a search engine does not necessarily mean that the Commission agrees with that classification. So obviously, this remains to be seen how the Commission will deal with it. However, I want to address one point, and that concerns a fundamental confusion that arises from the implementation of the DSA and the implementation of the DMA. The legal definitions are fundamentally different, and the objectives both instruments seek to achieve are also fundamentally different. Which leads me to the second point. Just to highlight a couple of aspects in relation to the first point. The DSA is about preventing the distribution of illegal and or harmful content. This is not what the DMA does, okay? And of course, the search engines under the DSA are subject to much less onerous obligations than platforms. This is not the case with the DMA. Search engines are covered by most obligations in the DMA. The other point that I wanted to mention is that when we see how these different tools have evolved, in the beginning, they were not necessarily qualifying as search engines, but this is not how I see things based on market dynamics. What I see is that these tools scrape the content, scrape URLs of all websites, as the DMA says, because the search engines definition under the DMA covers general search engines. Vertical search engines are online intermediation services. So in my view, search engines or ChatGPT would definitely qualify as a search engine under the DMA. And if you go to the definition of the DMA, you do not see a reference to providing conversational answers as a definitional criterion. This is wholly irrelevant for the purposes of the DMA. You need a service that provides an answer to a user's query that scrapes all websites. Obviously, it covers ChatGPT in my view. Whether the Commission will go down that path or not, I do not know, but I do think that the argument can be made. Hopefully that captures.
Thanks for the 10 answers.
Christoph Garrity from Digital Competition. Struggling with this question, Nicolas, about your point that you made that the publisher are suffering, especially the one about competition from chatbot with publishers. But I'm struggling about trying to understand the difference between competition as a result of disruptions, innovation, and you have to move on and adapt. Like in the 19th centuries, we use a horse in the street, and now we have cars. So basically the same today with generative AI. It's a new technologies, and you have to adapt. And my question, is it a competition problem whereas you have to adapt, or is it a competition as a result of an abuse of dominant positions? And here we have to make clear the difference. And remember that the DMA is about, we have the DMA because there were anti-competitive practices and that we want to regulate because they are systematic. Here, if there's a competition between chatbot and publishers, and this is a result of innovation, I don't see why the DMA should regulate a practice that is just an innovation process and just that you need to move on and adapt. So here we have to be very careful on that point.
It's an unfair innovation process, first of all, because it steals from the publishers without permission and authorization.
You have copyright.
Huh?
You have copyright laws that you can use if any is covered by copyright law.
Exactly. In order to substantiate anything on copyright, you need to know and substantiate the claim. The fact that all AI companies work in big black boxes without having any transparency obligation, for now, let's see what will happen with the AI Act, publisher cannot enforce the rights. I mean, there are already, in the US, there are already plenty actually, litigation cases, which show that there is a copyright problem. So copyright is one aspect, but competition is another aspect. what we said earlier about self-preferencing, for example, is still very much valid. And traffic, that's how publishers monetize their content. If readers remain in a closed ecosystem, with actually it is gatekeepers, all the digital gatekeepers that have closed ecosystems, if they remain in that ecosystem without allowing to go outside, but using publishers' content to attract to that ecosystem without remuneration of publishers, then there is a competition issue there.
Competition, but I don't see necessarily the abuse. Maybe competition because as a result that now they offer products that in enrich and you can use like Go do or Quen do. But if Google wants to do it and to have better product, I don't necessarily see the competition issues. But it's a big debate anyways.
Can I just make one quick point here? Because you said that you don't see the competition issue. What about unfair trading conditions and exploitative abuse? I mean, this is basically the theory of harm on which the French case, the French ancillary copyright decision case is based.
Yeah, correct.
The fact that we didn't pursue exploitative abuse cases does not mean that effects on traffic or not paying the publishers does not qualify as an exploitative abuse. There is a reason why the treaty refers to unfair trading conditions. When you don't pay a fair remuneration, that's unfair.
But again, we have to define whether taking content and is still in discussions for training should be covered by the copyright directive or not.
That does not make it irrelevant from the perspective of competition, though. Yes, you need to define it.
Yeah, I mean, it's still, but my point was more about whether there is a competition between the content that is produced, the output, and the news publishers in that case. Here we speak about the input where basically...
And the output.
And the output. My point is more on the output where there is a competition on the output, not on the input side.
But again, the input is used, the content is used without remuneration, without permission.
Well, this is should be defined, but I know there's case ongoing on that point. But if any, it's on the input side, that's the issue. But I was speaking more on the output side, whereas you have the output.
I think Elodie might want to mention something on this, because I know that part of the case was about Bard, now Gemini, not seeking the publisher's authorization.
We didn't address it in the...
Yes.
No, because it was about, like the commitments that Google had entered, because you have 17 cases on Google, the Google-related rights. But in one of them, the Google had entered into commitments, and those commitments were about negotiation in good faith, transparency, and so we found that they were in breach of those commitments. So we didn't go into the abuse part, but I think that would be interesting in the future.
Okay, so we are unfortunately at time, a little bit over time, and we're cutting into your coffee break. So I will end it there with just the final remark that we certainly answered some questions, but clearly raised some others. So can you join me in thanking our panelists?